It should be emphasized that any such obligation to prevent or at least minimize significant transboundary environmental harm depends upon states gaining general awareness of such harm or the risk thereof. While there is a range of views regarding when states gained this awareness with respect to greenhouse gas emissions, it is not necessary to make such a factual determination in order to provide an opinion on states' current obligations in respect of climate change. What is important for this proceeding is that states clearly have the requisite awareness today. International human rights law, however, does not obligate states to mitigate anthropogenic greenhouse gas emissions, nor does it currently provide for a human right to a healthy environment, although the United States remains open to participating in a state-led process to develop such a right. An advisory proceeding is not the means to litigate whether individual states or groups of states have violated obligations pertaining to climate change in the past or bear responsibility for reparations, as some participants have suggested. My first point relates to some participants' characterization of historical greenhouse gas emissions as a composite breach within the meaning of Article 15 of the International Law Commission's draft Articles of State Responsibility. It has been suggested that at the moment a state's cumulative emissions pass a certain threshold, a composite breach has occurred, and therefore all of its past emissions become internationally wrongful, even those occurring before a legal obligation was in place. We disagree. Put simply, acts or emissions that preceded the crystallization of international obligations with respect to climate change cannot be internationally wrongful acts. The Court has an opportunity to reinforce the ongoing negotiations in the UN climate change regime, including the Paris Agreement's ambition mechanism. It can do so by affirming the centrality of states' obligations properly understood under this regime.